Hello, how are you today? This is Bong Soo-jung, Korean labor attorney. Today I'd like to explain the characteristic of employee. So whether the person is employee or freelance is very important. Recently we heard a very big important court ruling about Uber the driver's status. So they used to be the freelancer or the private contract, but the British court ruled the Uber driver should be classified as an employee because they are controlled by platform business owner. Also their operation is controlled, and even the how to earn money is depend on their control and their job assignment. So their status should be classified as an employee. So this decision it affects many countries, including Korea, the judgment of employee status. So how there are the many jobs are very complicated regarding this judgment, like the partial the package delivery man, also the exclusive the bus driver that they own their own car, but they provide labor's driving service to like Intuit, like they are exclusively driving for the certain the Hagwon or Intuit. Also like many different types of work, like part-time the teachers working at private institute, also hair designer at the beauty shop, also the caddy in golf course. So they are very confusing. Their status decided by the case by case. It's not decided by their own name. So regarding Labor Standard Act, how to judge whether they belong to employee or not? So it starts from the definition of the employee. Employee means the someone who provide the labor service in return for the wage under the particular employer, regardless of their job. So this is how the Labor Standard Act define about its definition. So based on this definition, court ruled. So they provide some judgment criteria. So how do you call the types of contract is not important. The important is it should be judged based on the like subjective or substantial the relation in workplace. So based on that, the court ruling provide some 10 items how to judge whether they belong to or employee. There are 10 items to judge, but if it is divided into 2 items, like one is personal supervision part, so whether they are controlled by the employee's direction or whether the person is applicable to the rules of employment or company regulation. Also their work is decided by to certain job like location, and also they are engaged, they are like very the occupied to working hours. Also how to do their work is depends on direction from their employer. So it is related to the personal the supervision. So second one is the supervision related to the wage. So how to earn is depends on their performance, or it's basic salary, the fixed salary and incentive. Also they work is exclusive, and they have to be there should be not possible for replacement of their work. Also, whether they pay some income tax or corporate tax. Also, whether they are registered for social security insurance or not. Those parts should be considered for financial supervision or subordinate relation. So in this the factor judged, especially employees' decision, employees whether the items that employee can choose, such as whether they belong to, whether they are registered for social security insurance or whether they pay like corporate tax or income tax, they are decided by employees' decision on the superior position. So those items shall be judged not strongly, but it just be considered not important part. So those items should be judged collectively. Then that is how to quote. So in conclusion, about how to judge the employee status is based on actual practice for actual work relation. Also, it should be considered collectively those items like personal supervision or personal subordinate relation and some financial subordinate relation. It should be collectively judged. So this is how the Korean labor court judged the case about employee status. Okay, this is all. Thank you for watching. Bye bye.